rights and human rights that may suffer limitations, exceptions, derogations. The role of the principle of proportionality in assessing the lawfulness of a limitation and the limits of human rights, and the idea that human rights, most of them, if they're not absolute, they're in a sense elasticity, okay? That they can be weighted and balanced against other objectives, other rights, other interests, such as general interests. Then last week we discussed the idea that human rights do not, they originally started as only having a negative effect in principle, so states should abstain from causing a wrong, the hands-off idea. But then they moved they acquired also different scopes, including the positive dimension, where we ask from the state to proactively engage in protection, and that this is an obligation of means. The analogy I gave you with someone being a good doctor and trying to achieve the best he or she can achieve given the circumstances at question, at issue. Today we are moving so we are done in a sense with the constitutional dimension of human rights, and we're moving to the international dimension of human rights. Today and in the next two sessions, we'll see how human rights operate in the framework of international law, how they operate as part of international law. And then we will move on with examining particular regimes of human rights protection. Okay? So, international dimension of it. There are a few questions that we would like, we have designed the structure together to address today, but to ensure that there is a smooth transition in what we're doing, I will start first, and I will ask you to discuss with me the case of Behrami Saramati. Okay? So, what happened in that case? I'm done with talking, now it is you. What happened in that case? Technical case, difficult case. What happened? Do you still have the copy you bought at Nero just a few minutes ago? Yes? I mean, you can circulate it and they all kind of... So, what happened in Behrami Saramati? Just the facts of the case, first of all. What is this case about?
About a mine. Kids playing with mines. Unexploded ordnance. What, you want to stand up?
No, just speak up.
I'll do a little dance for you. And basically, one of the children found an unexploded ordnance long after the conflict had finished.
Where did that happen?
In Kosovo.
Kosovo. So, we are in Kosovo.
Yeah, it's after the...
What is the situation in Kosovo?
Post-Civil War.
Post-Civil War. So, there was a civil war in Yugoslavia, it collapsed, and you have a number of states succeeding, in a sense, Yugoslavia, or emerging from Yugoslavia. Not all of them are successors. Okay? Kosovo, arguably, is a state. Some of you did the seminar in the first semester. You may remember the ICJ opinion. We don't know if it is a state or not. Okay, so we have this entity. Who is controlling, who is administering that entity?
It was meant to be the UN.
The UN.
Yeah.
So the Security Council said this is a post-conflict area. There is danger to have more war crimes, crimes against humanity, etc. I need to ensure that this stops. So the UN decided to administer that territory. And?
The claim was against the state. So the state was responsible for demining, and the court found that actually it wasn't the state's fault, it's the UN's fault, and it was Resolution 1244.
Okay, so there is a tragic family that loses their child. Okay, why? There are some kids playing, they find the bomb, and the bomb explodes. Okay, tragical? Yes? Is this an issue of human rights? Yes or no?
Yes.
Yes? Why?
because the life right is the basic right for the people.
Okay, so the right to life, add question here, whether there has been a violation of the right to life of those people, of those persons who died, and then the family as indirect victims. Is this a positive or a negative violation? Positive. Any other ideas?
We have classified the right to life in the first category, on liberty, so it was supposed to be a negative action of the state and hands off the state, because it was a bomber. So the state will have the obligation to take care of the son or of the kid. So are we talking kind of field of security that could be covered under equality, under the second category?
So positive, yes, stemming from equality. In principle, liberty, but it could also be protection.
Yeah.
Any other ideas?
It's negative because when we classified it under ideals of French Revolution, we put it under liberty, where state is hands off. The state
So
needs to...
kind of the same answer here.
Yeah, first generation.
Any other ideas? Imagine you were a judge in that case. So a father comes to you and says, I lost my only kid. Why? What happened? He was playing outside our house and the bomb exploded. Would you say that this is an issue concerning the right to life? Is this an issue of protection, or so positive dimension, or it is an issue of respect, so negative dimension? Would you accuse whoever is to be accused for killing those people, or for failing to protect their life?
Well, it would be failing to protect, I'd say, because they have not carried out their duty on demining.
Demining.
Failed in protection. They haven't actively gone out to kill the children.
So I have one negative, I have a few positives. Any other ideas?
It's definitely a positive because there was no overt act on the part of the state in this particular instance. In the self-same allegation, we can impose that there is an imputation, over the state because of failing to create an environment or do something that would protect the life of that very unfortunate child. So it was, it is more largely positive sort of obligation from the part of the state.
Okay. I keep aside the question of whether this is a responsibility of the state, because this is something we will discuss later on, but for you it is positive. Just to address the two comments I had here, that the right to life is under liberty, so it has to be a negative one. Last week, what I explained to you is that we moved away from this classification between you're both Brazilians, by the way. So, last week we moved away, I asked you to move away from this classification between liberty, equality, fraternity, and negative, positive. You're Brazilians, too. No? Okay. She's married actually. So I asked you to abandon this idea, and I told you that the respect, protect, fulfillment classification applies in all families of human rights. So respect, negative. Protect, positive. We expect the state here not to do something, to abstain from causing the wrongful result, to abstain from killing someone. Here we expect the state to provide assistance, to do something in order to prevent a result from happening. Demining, okay, in our context. All rights, irrespective of whether they are civil and political, under, liberty, or they are economic and cultural in the second, like under equality. All human rights, and we will see this in much more detail when we will be discussing the International Covenant on Civil and Political Rights and the International Covenant on Socio-Economic and Cultural Rights. All human rights develop respect, effects on the respect, protect, fulfillment. So, every time you have a lawyer, a case, I was telling you last week, the first question you need to ask yourself is there an interference? Is this an issue of human rights? Yes, right to life. The second question, is it a negative or a positive? Some of you told me that this is a positive because of demining. Would anyone say that it is negative in the sense that someone has thrown that bomb there? Yes or no?
No.
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 No. Why?
Because the public authority have the responsibility to protect.
Because, sorry,
the public authority have the responsibility to protect this area's safety.
I accept that. So there is definitely a dimension under protection. Is there also a dimension under respect? Do you know any bombs spontaneously emerging from Earth? Is it like a plant? You put this. Someone has put the bomb there. This is my point. Isn't that person, whoever is that person, responsible?
We have to ask, I don't know if this is like a question possible to answer, but is it the state that put the bomb there or not the state? Because like the negative right, isn't that the state has to the state has to respect human rights so they can't kill their citizens. So is it the state that put the bomb there and kill citizens?
In that case it was NATO who has
Exactly,
thrown
so
the bomb. So my point here, good point, is that that case raises concerns from both the negative and the positive perspective. One entity, one person can be responsible because they have thrown the bomb, killing people, and another person, or the same person, but can also be a different person, is responsible because there was a bomb there for some time. They knew that this is putting at risk human life. They could have acted, so knowledge and ability to act to prevent this from happening, but they said, okay, it's a bomb, it's nice, let's leave it there. Okay? Next question for you. Did the court, the European Court of Human Rights, enter into the debate, into the question of whether this is negative or positive? Yes or no? In the judgment. Did the court discuss that? Yes, no? It's 50%. No consequences if you give a wrong answer. So just say yes or no so that you can move on.
Maybe.
Maybe. The answer is no. The court did not examine this.
Not good.
Why? What is the legal issue, the particular legal question that the court had to examine before addressing that issue?
Is rationale personae? Is the rationale personae?
It is there, sorry?
Is this the rationale personae?
Russian personnel.
Yeah.
Russian, why Russian?
Ratione
Ratione, yes?
personae. Yeah,
Ratione persone. Okay, yes, good point, yes. elaborate on it?
Well, initially you have to make sure that you've got the right plaintiff.
Mhm.
So, you know, they're saying, well, we're going to attack him. It was a France and Norway, was it? I can't remember. 2 foreign states to Kosovo. So you're responsible for dropping the bombs.
So the question there is ratione personae with regard to what person is responsible.
Yes.
Yes.
The discussion we did here, negative, positive, right to life, etc., is a discussion that would follow had the court established that ratione personae, with regard to the person that is responsible, the court has the jurisdiction, has the power, the competence to examine the case on its merits. So, just to make things, to link them with what we are doing here in the structure. The question of negative, positive, and right to life is the constitutional dimension of human rights protection. This is what the court would do after establishing who is responsible. But in order to answer that question, it is a question of constitutional law or international law. Who will tell us, what law will tell us who is responsible? International law. Why?
If you want to concern the responsibility of states or private actors, different actors, not only states, so we have to look for that.
The European Court of Human Rights is an international court. It has been established by the means of an international treaty, which is again international law. It exercises competencies that have been given to it, and its task is to establish and sanction, in case of establishment of responsibility, but to establish the responsibility of states. All these are questions of international law. Exactly the same question could have gone before domestic courts in Kosovo. And in that case, prevailingly they would apply domestic law. They would also have to refer to international law, but in the case of the International Court of Human Rights, a precondition for it to continue with exercising its functions and tell us, is there a violation of the right to life, who had an obligation to prevent, who had, etc., all this discussion, first it had to establish that ratione personae, with regard to the person that is responsible, it has the power to exercise its function. And it only has power to scrutinize the conduct of states. So, for those of you who did international in semester 1, what are the 2 preconditions, what is the twofold test that we have to do in order to enter into the field of secondary obligations, to apply the law of state responsibility? Do you remember?
Attribution.
Attribution and breach.
Right.
So the court here is doing in reality this twofold test. It says, you know something, you're telling me that Serbia, Kosovo, whoever is the respondent state is responsible. Well, before that, let's say, is this breach, alleged breach of international law of the European Convention of Human Rights attributable to the state? Yes or no? What did they say? What is the reasoning of the court in that respect?
But it didn't have jurisdiction to rule on an action that was being authorised at the UN Security Council.
Okay, so they said, I don't have jurisdiction, I'm the European Court of Human Rights, I'm an international court that can only exercise powers that have been given to it. States only gave me the power to scrutinize the conduct of the signatories of states. But this is something that has been done not by the state, but by international organization. So the court, in this judgment, which is a preliminary judgment, is a decision on the admissibility of the case, it goes back to the parents of the victims and says, I'm really sorry, I sympathize, my most sincere condolences for your loss, but I don't have the power to scrutinize, to examine that case. I cannot tell you if there has been a negative or a positive violation of the right to life. Why? Because I'm an international court and I only have limited powers. And the precondition for me to exercise my power, to do my job, is to do it against the states that have signed the treaty. But in that particular case, I am asking who did that, and the answer I'm giving is the United Nations. Next question. Do you agree with the court? Do you think that the court, this decision on the admissibility is a correct one? No? Why? Eh?
I think it depends.
It depends.
It depends because it looks at what perspective you look at it from. So if you, I guess you're an advocate of human rights, then you're going to question that decision. But then again, the court has to have limitations to its jurisdiction, which it has to operate within. So it depends what perspective you feel.
This would be a good argument if you were someone who is in favor of human rights or against human rights. But this is in a sense also ideological. But as a lawyer, if you read the law, so we have established that the court has to answer the question, in terms of admissibility, of attribution. What are the rules on attribution? Did the court apply those rules correctly? You wanted to say something?
I was going to be something that was related to human rights. So I was thinking that in this case, of course, it's not only the case because it was related to the United Nations and the United States, but then it brings us to the discussion of how important are human rights and how they should be protected. If it should be based only on the legal competencies that the court has, or if you actually have the responsibility to go further in order to guarantee the protection of human rights.
Go further. Okay, so again, ideology. I'm translating those two arguments, and you will see that these are central to international human rights protection. What we will do next week, the humanization of international law, behind it you have exactly this idea. The logic is, human rights is not like trade, it's not like it's not like selling you potatoes and getting bad money. Human rights is important. Human rights has to do with the protection of human life. Someone died in Kosovo and we want accountability. So, we should be allowed to push a bit the rules of international law so that space can be created for human rights to prevail. Okay? This is the logic of the humanization. We will discuss it next week. Okay? But my question for this week is, technically speaking, okay? The court is doing a test of attribution. Did the court do correctly that test of attribution? What did the court say? First of all, is it a question of state responsibility or of responsibility of international organizations? What is it?
Is it not international organization?
International organization. So, the court had to examine a really thorny question. Why? Because we know that for state responsibility, we need a breach and attribution. Most of the times it is easy, attribution is easy. It's a state organ. But when it comes to international organizations, the problem is, this is the international organization, and these are states. The big question you have with regard to international organizations is, when I should pierce the veil, create a hole here, so that I can hold accountable the state and not the international organization. So, when NATO is bombing Yugoslavia, the question is it NATO or it is the states that have given, that have borrowed, that have provided the means to NATO to do this? Okay, so this is a very technical, a very thorny question. And the European Court of Human Rights, in order to answer that particular question, it refers to the ILC norms draft at the moment. It wasn't finalized, this project, on the responsibility of international organizations, and to the question of whether it is the state or the international organization. In reality, the court, in that case, is not at all a constitutional court. It is a purely, merely an international court. Do you understand that? I will tell you what the court said in a minute, okay? And I'll stop there. But do you understand here how my argument, my idea that human rights, when we took them from domestic law and we transplanted them in international law, that they also acquire an international dimension? Do you see how this is an example of how international law preconditions the application of human rights, the constitutional dimension of human rights? The court cannot proceed with becoming a human rights court unless it has first solved this issue, which is an issue of public international law. Clear? Yes? Everyone? The court in that case said, well, this was done by X case. France and the France that are France and the other states that are... But these states were operating in the context of NATO. And NATO was there because the United Nations Security Council authorized them to be there. So it created what we call a chain of command. And it said, the Security Council gave the command, gave the power to NATO to be there, and NATO gave the command to French troops that were administering, that were like a police in the area, that failed to demine the area, or that left the bomb there. Okay? Negative or positive, it's a question we're not raising. Does it look rational to you? Do you accept this logic of chain of command? I can tell you that legally speaking, technically speaking, this is accurate. But do you think that there is indeed a chain of command? What is the UN Security Council?
I'm not sure about it.
I think it's, at the end of the day, maybe it's wrong opinion, but at the end of the day, everything comes back to the state, because who creates Security Council? The states.
Yes, yes. This is the previous question of when do we pierce the veil. Yeah. Let's say that the ILC has said that in principle you don't pierce it, unless if you can establish intentional causality. So leave this aside for the moment. In principle, if this is something attributable to the UN, it is the UN that is responsible. And if it is the UN, the court has no competence. Okay? We'll see next week what this changes. But for now, okay. What is the UN Security Council?
Made up of 5.
Permanent states,
And then
another 10 which are not permanent.
yeah.
Indeed, the UN Security Council created this framework. But do you think that there is an actual chain of command? Do you understand what is a chain of command? What is a chain of command?
I don't think there is a chain of command. I think there's a hierarchy, but not a chain of command.
Okay, why? What is a chain of command?
Well, the chain of command ends at NATO because they're operationally in charge.
Uh-huh.
And the
But
UN
not
security
the-
is those who say, well, we're the hierarchy and we give you the authority to go and wage war.
The rest of you, you wanted to say something? No? No?
What do you mean exactly by chain of command? Like to be following instructions?
Following instructions, and you have an hierarchy. So, what the court implies here is that the French general who was in charge of this before doing something, would call the general in NATO. I would say, okay, we have this bomb here, what shall we do? And then the general in NATO would call the UN Security Council, whoever is that person, say, well, we have a bomb there, what shall we do? And then you will have a meeting of the 15 member states and will say, well, there is a bomb over there, shall we leave it there, it's fine. But this is not factually accurate. The UN Security Council created that framework, legally speaking, but there was not a chain of command. Okay? So, point number one, I want you to remember. International human rights protection has a constitutional dimension, right to life, positive, negative limitations, proportionality, but quite often a precondition will be a question coming from international law. International human rights protection is that we apply protection of human rights in the framework of international law. And quite often you will have quite technical questions of international law that need to be addressed. I can give you more examples. Extraterritoriality, issues of jurisdiction, questions of attribution like this one. Okay? So this is an example, and this is why I gave you, there is another reason why I gave you that case, you will see it next week. But the first point is that this is a case where you have a precondition is a question coming from international law, and the European Court of Human Rights operates solely as an international law court. Okay? The second point is we have established that maybe the court was mistaken, in brackets, in that decision. Can you think of any good reasons why the court was mistaken? Why the court attributed wrongly everything? So the court says for everything the responsibility is the UN Security Council. No one else has responsibility. Why did that? It is explaining this in the case.
You say that they didn't really follow the norms of like the test of attribution, so they kind of, where normally you would say it's whoever has effective control, they deemed the UN to have that effective control, but the norms of everyone else and the rest of the international community would normally say that actually France did have effective control because the UN had passed that effective control down to France through the resolution.
Yeah, this is exactly what I'm saying, is that the court attributed to effective control everything to the United Nations. It pretended to apply international law, but it applied international law in a way that for everything put the blame on the UN Security Council. Why did that?
Because only the UN Security Council under its Chapter 7 has the power to
Authorize.
Adopt coercive measures in response to a specific situation.
And the UN Security Council in that case, it did that. Chapter 7 resolution, and said that on the ground, I want NATO to administer that territory. And NATO went there, and NATO said, okay, I have French and Polish and English and Americans who will do the job for me. And you have a question of who is responsible for that. The court said, everything goes to the UN Security Council. And we established here that maybe this is not accurate, this is not correct. Why did the court put everything? So it pretended to apply international law, but it applied international law in a way that was very convenient for it. Why? It is explaining this in the judgment.
Was it to maintain peace and security?
Yes. How? Elaborate.
Saying, well, there's a greater good here, and we don't want to prosecute different people because the main aim of everything was to stop the war.
Okay. Yes. A little bit further. Your reasoning.
Human rights made an important contribution to international peacekeeping.
And?
Well, difficult to read now.
If the court... Sorry.
Was it also just that you would place conditions on Security Council resolutions, and there was no provision in the text of the resolution to present conditions.
Yes, but still the court could say it is about conditioning the UN Security Council and scrutinizing its conduct, but the court could simply enough say, I'll do it. I'll do it not directly against the United Nations Security Council, I do it by piercing the veil. I will do it against France, which is a member of the UN Security Council. Is it? No, I will not do it in that case. Why? Peace and security.
I didn't hear the question.
Why the court refrained from scrutinizing the conduct of the UN Security Council indirectly through member states?
I've got it here. The operations set in motion by the Security Council resolutions under Chapter 7 of the UN Charter were essential to the UN's mission to preserve international peace and security and rely for their effectiveness on the contributions of member states.
What the court is saying, I could pierce the veil and scrutinize the conduct, apply my full test against the member state for what the Security Council did. However, I will not do it. Why? Because this is the Security Council. This is the god of international law. This is the most important institution in the world. And their operation, their function is associated with peace and security, and human rights should not be an obstacle to peace and security. So the court is very willingly making a political decision. It says, I will attribute everything to the UN Security Council so that they don't scrutinize the conduct of France. Why? Because I don't want human rights to be an obstacle to the functions of the Security Council, to peace and security. If we start scrutinizing the conduct of those missions, then states will not want to contribute. And if they don't want to contribute, those people will continue killing themselves. How do you find this idea? Is it a good idea? Do you agree with the court?
No, I don't agree with the court.
What would you do?
I think it should come to France because she's the one that enforces the peace, but not the UN.
Why?
Actually, because she has the force and she controls the area. And this is the reason why.
But the court is implicitly saying, if I would do what you say, and I would scrutinize France, then France, this is in between the lines. That would be me indirectly controlling the UN Security Council through France. But I can lawfully do it, because France is a signatory to the treaty. But if I do that, then no one will want to cooperate with the UN Security Council, and then France will not go again to Kosovo. And then if I do that, people will continue killing each other in Kosovo. So I prefer having one child killed because of failing to demine the area than undermining the ability of the Security Council to effectively address those situations.
It's not necessarily what I agree with, but could it be argued that because in the United Nations Charter, in the preamble, it states that one of the purposes of the United Nations is to reaffirm faith in fundamental human rights and the dignity and the worth of human person, this argument is fundamentally against one of the purposes of United Nations because of the worth that is placed in human rights.
Okay.
So it kind of.
Do you agree with this?
Oh no,
Morally
absolutely not.
Okay.
I think UN is quite important for the greater good, but it's just a potential argument against it.
Kind of ironic because UN both mentions about fighting for peace, but for me fighting for peace itself is ironic. Fighting for human rights, using force and human rights, peace, security. This is like more moral question. This is what you want. is it more moral to maintain peace and security, or is it more moral to keep human rights?
The priority. What is the
Yeah,
priority?
what's the priority? How the court and how we should choose one of those.
I was just going to say that one of the problems surely is that there isn't a remedy for the individual against the United Nations. So
There is no remedy.
So if we're saying that, oh, it's the United Nations, it's their responsibility, then the
There is no
individual
remedy.
doesn't have
Yeah.
an opportunity to go through a court with them. But whereas they only have that remedy within the European system.
If there was a remedy against the United Nations, then those victims would directly go against the United Nations. Okay? I think I said this in the class in the first semester as well. I told you it is sexist, absolutely sexist, but I'm allowing myself to do it because I'm from the south of Europe. Okay? That in Greece, we have this expression that I'm talking to my wife so that my mother-in-law can listen to my complaints. So instead of going directly against my mother-in-law and telling her, you know something, what are you doing there, etc., I go to my wife and say, well, it is not very good that this happens. And then the mother-in-law listens to it indirectly, okay? It is the same thing, against going directly against the United Nations Security Council, because there is no remedy at the international level, no legal avenue to scrutinize the conduct of the United Nations Security Council, they go against the state, against the wife. And they expect the European Court of Human Rights to talk against the wife, France, so that the UN Security Council listens and says, well, what are you doing there? You're killing people. You're pretending to save their lives, but you're killing them. So, there is no remedy. Should the court have gone against France then?
I'm not sure, but does it go as to the fact that France is a permanent member of the Security Council, when they vote in favor of a resolution, that is deemed as them not voting as a member of the United Nations?
Very good point. They didn't enter into that question. Why? Because A, in theory, but we can criticize theory, and what the ICC did is that the autonomy of the international organization, so how you vote as a member of the Security Council doesn't really count. However, and this is a really good topic for a dissertation if anyone is interested, you have doctrine, scholarship, challenging this, especially in the context of responsibility to protect. So some arguments say, well, if you know the R2P doctrine, those of you doing use of force, you have discussed it. So if the Security Council doesn't authorize use of force, we know who voted. You should be responsible for that, so we should pierce the veil of the Security Council. So this is a good, there is literature, this is emerging, good topic for a dissertation. I'm just giving you ideas here, okay? So, very last question. Would you, given that you cannot directly go against the UN Security Council, would you go against France, yes or no? Just raise your hands. Who would go against France? Yes? The other of you? Like, just don't be shy. Unless if you're British and you don't like France, and then no. So, against France, against France, against France, against France, yes? No? Against France? Okay. So let's see, you would save one life and you would let thousands of others die. Congratulations. We're very many killers in this.
I don't think it's exactly that the point. I think what we should be thinking about is like how to make it compatible to protect or to maintain peace and security, and also to guarantee the protection of human rights. The problem here is like a very political issue, because then you're going to put under pressure to the states, and they are not willing to.
And you have that kind of moral dilemma.
Yeah.
Do I go against the Security Council indirectly through France and punish it through France for what it failed to do? Or do I leave it there and say, yes, some people will die, you will make mistakes, but you're important, we need you there. This is the big political question behind this issue. Next week, I've asked you to read Nada versus Switzerland. I'm telling you beforehand that Nada, why you're laughing?
Because they say like nada, like nothing.
Ah, Nada in Spanish, yeah. Nada, that was the name of the case. So, Nada. That judgment is exactly the opposite from Behrami Saramati. The court in Behrami Saramati says, I will not touch the Security Council. And then in Nada, it says, I'm here to protect human rights. If you want human rights, you come to me. Okay? I will go against the Security Council, I will go against the moon, against everyone to protect human rights. Okay? Just read the case, read the reasoning, and we will also discuss the political motivations to see also how justice is very political sometimes. Okay? Exercise for you. 4 and 3, 7 of you, one group. 1, 2, 3, 4, 5, 6, 7, 8, second group, and then the rest of you here, third group. The question I want you to identify ways in which international law had to change in order to accommodate human rights. This could possibly be one, okay? Responsibility of international organizations and state, allocation of responsibility. In ADA, actually, international law had changed in order for the court to indirectly scrutinize the UN Security Council. You will see this next week. I want you to think and more basic things, okay? The ways international law had to change in order to accommodate human rights, okay? One group, second group, third group over there. 5 minutes.
Treaties had to change and the language had to change to focus more on the individual rather than the state, and effectively the individual becomes a subject of international law.
Okay, individuals become subjects of international law. Treaties changing their language in what sense? In the sense of the content of the treaty? Yes, of course, this is obvious, but is there any other effect on treaty law because of human rights?
I just thought from the perspective that it's written about the individual rather than...
There is a debate about that. Pretty much of what we're doing now, this is actually a link to what we will be doing also next week, and the reading I gave you is relevant to that. But treaty law, yes. Other ideas? Are you done or?
Treaty law, reservation on human rights.
Reservations on human rights, there was a big debate. Okay? You will see this in your readings, yes. So what happens to reservations to human rights treaties when they are found to be incompatible with the object and purpose of the treaty? Do they still apply? Is the state bound? Yes or no? Other ideas?
We kind of said, I'm not really sure, but kind of the idea that in international law there's no hierarchy, it's horizontal, but human rights have almost started to develop a hierarchy.
International law became, initially was just a flat horizontal legal system because of state sovereignty and equality between them. But now you have an emerging hierarchy. Again, this is in the reading for next week, you will see it.
I was going to say that there is a vertical relationship now between the states and with human rights idea, or that's the idea of international humanization of human rights.
The vertical thing would work like that. So this is domestic law, the state, and the individual. Next to it, you have other states and individuals. Other states and individuals. This was domestic law. French law, English law, Brazilian law. But then, you started establishing obligations between states as well. Okay? Initially, everything is the same. Through treaties like we do always. Business as always. However, because human rights is something different, then the vertical dimension hierarchy means that the will of states is limited. Human rights is, and it is limiting the state. It is exactly the same idea that you raised earlier. Because of human rights, because they are special, should I apply international law in a different way so that human rights prevail? Hierarchy is especially associated with what? What type of rules? Use cogence, and then possibly. Again, we will discuss this next week. Having mentioned any other ideas?
Well, international law started placing domestic obligations on states to protect individuals out of obligations arising.
Self-executing treaties, going back to treaty. So you have a treaty like the European Convention of Human Rights. This is international law. It directly creates rights for the individual who can apply international law in the domestic legal system, and sometimes directly, like at the international level, like in the case of the Inter-American Court or the European Court of Human Rights. Okay? And this has to do with the idea of an individual who can actually be a participant at the international level at the same ranking as states. It is Vallanatos, we discussed last week, versus Greece. You have a state, a sovereign state, and on the other hand, you have an individual. And the two of them have a conflict, an international conflict, dispute. Other ones?
The sovereignty role is a little bit changed in order to guarantee the human rights protection. So sovereignty would be thinner, and yeah.
Because the one state will be monitoring what the other state is doing in its domestic legal system. Okay? The list is big, and we will discuss this in more detail next week. Okay? You mentioned use cogents and their governance, which is the next important debate we need to make today. And I'm passing this over to Sufyan. So I will sit here, and I will relax and join your discussions.
Hello everyone. Vasilis, thank you for inviting me here. I'm very glad to be here. I'm sorry about my voice. I was completely voiceless last week. And I hope you can hear me. I'm very well impressed about you, about the discussion that we just had. I think you were the discussion was very interesting to witness. So I made some modifications to what I had in mind because of this discussion. Okay. So I'm going to talk about the advisory opinion of the Inter-American Court of Human Rights on the rights of undocumented workers. I would like to call your attention for three things in your discussion. Okay? The impact, what this case illustrates about the impact of human rights on sovereignty, what you were talking just now, about the idea and the definition of the individual in the international law, and about fragmentation of international law. Okay? These three things, have them in mind. I know that the impact of human rights on international law is much broader than that, but just let's focus on that because of our time and everything. So the first thing that I ask you is, what is the Inter-American Court of Human Rights? What do you think the Inter-American Court of Human Rights is? What's its legal nature? What it is? You already answered that in regards to the European Court of Human Rights. What is it? Anyone? Come on.
We had Velasquez last week.
Yeah.
It's a regional human rights enforcement court of which American states in North and South America, others are bound by when it's responsible for enforcement of human rights.
Okay, let's just elaborate a little bit on this, okay? Does it have the capacity of enforcing human rights on states? What's enforcing? What does enforcement mean? It's very important. This will have something to do with sovereignty. Can you enforce human rights in states? How do you enforce it?
I'm not sure, but I thought I read somewhere that it was only advisory.
Sorry?
I'm not sure, but I think I read somewhere that the Inter-American Court was only advisory.
Yeah. This thing, I'm going to bring some information for you. This is a very capricious thing, something that is very subtle. We have the cases and we have the advisory opinion. This is an advisory opinion. Advisory opinion, because it's advisory, it's not mandatory. Okay, we'll talk about that later. But in regards to cases, Does the court has the capacity to enforce it? It doesn't have this capacity. Because the court is part of an organization, an international organization. This international organization does not have the force to go there and make the state comply. But some things has been happening in Latin America. For instance, in Brazil a couple of years ago, we had a modification of the civil procedure law code. We have this code, civil procedure law, and in one part of this code, this codex, this piece of legislation, we have a provision that says that cases of the Inter-American Court can be enforced in Brazil by the Brazilian authorities. So it's something different, okay? I'm just bringing this to your attention because enforcement is a very tricky word there. But you're right, that it's an international organization. It's part of an international organization.
Can we say that their job is to monitor and implement human rights as opposed to enforce?
Yeah, you're closer to that. It's a bit more than that. It's going to monitor. It's going to say, because when you monitor, you also have the capacity to say, listen to a state like the Brazilian state. You violate the Inter-American Convention of Human Rights. And then there's a lot of pressure that comes from the state. And this leads me to one thing. What are the limits of the Inter-American Court of Human Rights? In legal, political, and practical terms. Let's think a little bit about that. What do you think are the legal limits of the Inter-American Court of Human Rights? States came together and made up an organization. There is this court. What are the legal limits?
What applied, the judgment passed in one case only applies to that specific country or that specific case. It can't be derived or applied to other situations unless the court makes such a ruling.
Yeah, but case law in every court is also always important.
Yeah, but it doesn't have a binding nature.
It doesn't have a binding nature. It doesn't have a binding nature. But be very careful with that, because the fact that it doesn't have a binding nature doesn't mean that it doesn't wait on the okay. But I'm talking, yeah.
The jurisdiction of the court is only by consent of the state, so states have to be party to the jurisdiction of the court, and they can choose to withdraw from that jurisdiction.
Yeah. Anyone on that point as well? Anyone else?
The sovereignty of every state would be a limit of the Inter-American
Sorry?
Court. The sovereignty would be a limit for the Inter-American Court. Like, they would be binded only as long as far as they are allowed to.
The sovereignty of the Inter-American Court.
Of the states.
Of the states will be limited by the Inter-American Court.
No, in another way. So,
Okay.
the actions of the Inter-American Court would be limited by the sovereignty of the states.
Great. That was on point. But in political terms, so you have two things here, sovereignty, and the Inter-American Court would in principle be limited, restricted by the sovereignty of the states. In political terms, do you think that the Inter-American Court would like states to withdraw from it? Do you think so? Do you think that the
Depends on if there's any
Inter-American
awkward cases.
Sorry?
It'll depend on if there's any awkward cases that they want to avoid.
Do you think that this is a concern of this type of courts?
I think it's a concern for all
that-
states.
Sorry?
I think, as Maria said, talked about sovereignty, it's a concern for all states when judgments go against them. I think the first impulse is to rely on sovereignty, is about, this is our country, not yours.
Yeah, but when you talk about sovereignty, it's something, but when you talk, let's talk about political, diplomats there and everything, and people there, and sometimes a decision of the Inter-American Court of Human Rights reverberates in Brazil in a completely different way. Sometimes Brazilians say, what this court wants to do with us? Does the Inter-American Court, do you think that it feels compelled by this kind of political pressure or not?
Yeah.
Who said that?
Yeah, I
Why?
think it will be, because
You see it in all international organisations, don't you? By their very nature, they're set up by states are signed up to them, and if they make decisions that they disagree with or could cause some problems, states will just walk away from the court, and then once they've done that, the court has no jurisdiction at all, and so they need the support of those states, and so that's how politics comes into it.
And in practical terms, do you see any restriction to the court, any pressure that comes out from the practical life, the day-to-day life? Who pays the bills that the courts have passed? So what I'm trying to say to you is that there are many, prima facie, okay, apparently, there's many kinds of restrictions.
Are you saying the court is susceptible to pressure from the states because of the funding that they give to them?
Sorry, come back again.
Are you saying that the Inter-American Court is susceptible to pressure from the states because of the
let's
funding?
talk, we're going to go to that, exactly that. Thank you for your question. Do you think that the Inter-American Court has an ethos, has a will, has a personality, that it can react to this kind of pressure? Legal terms, why not? It is an entity that's different from the states, isn't it?
But financially, it depends on the states.
Yeah, but doesn't the court have something that is called legitimacy? What's legitimacy? Do you think it's easy for a Latin American country to say, okay, I'm not going to pay for what I owe to the court? Do you think it's easy for a European country to say, I'm withdrawing from the European Court of Human Rights?
Unless you are the UK.
But still, is it easy? Is it easy? It's not that easy. So my question is, does the court has something that's on itself can respond to this pressure? What do you think? How do you feel? It's very important in this advisory opinion, because you're going to see this in this advisory opinion. Do you think that the court is something different from the state and can react to these positions of the state? What do you think?
Yeah, well, because the court can create rules and obligations that are binding to the states whether or not they choose to. Because it can create, arguably, certain rules that can become sort of customary or use cogents, so that the states are bound by them whether or not they're party to the convention.
Okay, so the court has, like every court, it has a power that's typical of courts. It has a power to say what the law is. Okay. And then, yeah.
There's a question if the state listens to that or not, because as we say on, for example, USA example, not necessarily comply with international law in general. Despite the fact that even if something is emerging as a customary law, they still not necessarily want to apply it. Because of course, for some states, it's hard to say no to the court, but for the United States, we saw many examples that it's easier.
I think it's that easy.
It's easier for them, definitely.
Sorry?
Yeah, I was going to say, for the states, I think it's easy for them.
I don't want to enter into this debate right now, because otherwise we won't have time to see what we need to see, but we can come to that later, okay? Just one thing. When you have a court or an international organization affirming that the United States or any other country violated international law, you create a range of problems for this state. Not only international, but domestic. Because the United States is not a uniform thing. It's lots of people, different institutions, and some of those institutions will draw on that ruling in order to put pressure on their government. Okay, so it's not that easy. It's not that simple. Okay, it's not as easy as sometimes you believe. Okay.
Unless if you're North Korea.
Unless you're not, but look at the price of that. Look at the price of that. It's completely isolated, bankrupted. It's a perilous. But let's go to the advisory opinion. You come back to the last question that you made. Do you remember?
Susceptibility. Susceptibility from funding pressure.
Yes, that's a very important thing. What do you think happened in this advisory opinion? What were the facts behind this advisory opinion?
Mexico requested an advisory opinion because migrant workers in the States weren't being undocumented migrant workers were having their labour rights taken away from them. They weren't being treated as fairly as they should have been.
I think this is a highly political issue.
Yeah.
Is it a highly political issue at this moment in the UK? Try to imagine the European Court of Human Rights saying, "Magdu, you cannot," well, it doesn't happen like this here, but try to imagine how this advisory opinion reverberated within the United States. Okay. So we have something there, but there's some, how the court responded to this request. What did it say? Now I want you to pay attention to something. First, the court has a rationale. No, it develops a rationale. It develops a narrative in order to, it tells a story and then makes a conclusion, okay? Basically. And I'm telling you, in telling this story, there is a framework, a theoretical framework. And there is also case law. Who talked about case law? You talked about case law. Case law is not binding on the court, but it makes part of this framework, this background. Okay? In this background of the court, how is the question of sovereignty dealt with? And how is the question of sovereignty? Is the court worried, concerned about sovereignty when it affirms that the principle of non-discrimination is jus cogens? Is it concerned about sovereignty, or is it concerned about something else?
It's concerned about individual rights and states' obligation to protect those individual
What's the
rights.
impact of this in international law? We have two impacts immediately
Impact
on international law.
the fact that international law is now not only looking at obligations of states towards international organizations, but also states' obligations towards each other to ensure that individuals within states are protected. Moving from a system of state-centered international law towards individual-centered international law.
Okay. So the framework of the court, you're saying, is a framework that's individual-centered.
Yeah, protection of individuals and enforcing state obligations for protection of individuals.
Is the individual a subject of international law?
Yeah.
Yeah. Great. Who thinks the individual is a subject of international law? Come on. Raise your hand.
What's the question? Sorry.
Who thinks that, I'm sorry for my voice, who thinks that the individual is a subject of international law? I believe this. No? Who doesn't? No one? Okay. So you see that the framework, the background of the court, in order to provide this rationale, is a background that's it's individual-centric, despite the fact that all those restrictions of the court would lead us to think that the background would be sovereignty-centric. So, is the court susceptible to the pressure of the states? Yes, it is, but it's also capable of reacting to it. Okay? But who is the beneficiary of this affirmation that non-discrimination is jus cogens? Who is the person who benefits from this? The international subject who benefits from this? Is it the individual or is it the state? I'm just taking one. I will not repeat myself. Is it the individual or is it the state? Who is the beneficiary of this? The individual. Do you think by any chance states could be beneficiary of this as well?
Say indirectly that they are.
Why?
Because if individuals within a state are benefiting from labour rights and so on, then what they put back into the economy.
What's the definition of state? You remember?
But
3 things.
Yeah, a defined population, no, permanent population, defined territory, ability to enter into relations, and government.
So maybe governments are not beneficiary, but the states certainly are. Okay, depending on the definition of state that we have, and depending on where we put the emphasis on the definition of state. But there's another thing here. The UN Charter says that doesn't talk about sovereignty. It talks about sovereign equality of states. If states are equal, there's something that makes them equal. What is this thing? Cannot be sovereignty.
One state, one vote in the United Nations. Same amount of representation, no matter what the geographical size.
Yeah, but
or
just let's go out of the United Nations. This now is a principle in international law, that is a principle of sovereign equality of states. What makes states equal? Because if you're saying they are equal, you need to have a referential. What is the referential?
The fact that each state has its own control over domestic law, and no other state can interfere within the domestic jurisdiction of another state.
Oh, that makes sense, but from an international perspective, what is the thing that we can use? We can use several things, but in this class we're talking about one thing. What's this one thing?
Is it consent? No.
It's international law. International law is the referential that from which you can say, well, states are equal because they have the same rights, at least the same fundamental rights. And then I come to the question of fragmentation. Is human rights law part, international human rights law part of international law or not? Is it or not?
It is.
Do you think that the principle of non-discrimination is jus cogens?
There are certain instances where an equal treatment is allowed. For example, in sort of certain rights that are accorded to citizens based on nationality or citizenship, for example, voting rights. Or in circumstances, for example, in prisons where children are supposed to be placed in the same prisons as adults. So that is not the same or equal treatment, but the overriding principle there, which is non-discrimination, I feel like has achieved a status.
Who thinks that the principle of non-discrimination is jus cogens?
Before that, what is jus cogens?
What is jus
A
cogens?
brief definition of jus cogens so that we can assess then whether non-discrimination fits into that box.
Norms from which there can be no derogation.
From? Who states cannot derogate from?
No,
Yeah.
norms from which there can be no derogation
Yeah.
imposes an obligatio erga omnes on states to not deviate.
So the erga omnes, no derogation, other.
Same thing?
Peremptory norms?
Yeah, what's the difference between peremptory norms and erga omnes obligations?
Erga omnes obligations are created because of the existence of peremptory norms.
So, all norms of jus cogens are they erga, do they give rise to erga omnes obligations?
Yes.
All of them?
I think so.
Yeah. All?
Oh, sorry, I was gonna, I mean, jus cogens peremptory norms apply to everyone, to every state, whereas erga omnes could be erga omnes universal, or else it could be erga omnes partis. So it could be only between two or some states, and also between the universal or the international
If
community.
they stand from a treaty, that
Yeah.
jus cogens too can stand from a treaty. Like Article 3 of the European Convention on Human Rights or the Inter-American Convention, non-discrimination, is jus cogens. This is stemming from a treaty, and the court says it is jus cogens. Do we believe it?
How do you ascertain the existence of jus cogens? How do you say, is that a method to ascertain jus cogens?
being written down in a treaty?
Sorry?
Do you mean written down in a treaty?
Well, let's go back to what is jus cogens. What kind of norms can be jus cogens? Treaty norms can be. Can we have jus cogens norms arising from treaty norms?
Yeah.
From customary international law?
Yeah.
From principles of international law?
Yeah. General principles.
But how do you say that a norm became customary international jus cogens?
State practice.
Sorry?
An element of it could be state practice.
So what's the difference between jus cogens and customary international?
Use cogens could be those aspects of customary, like not all customary. Okay, no, I'm not getting straight. Okay, so use cogens could be customary international law, which all states have been forced to practice, where they can't derogate from it.
Yeah, that will lead us to a very, very limited. Let's go back to that afterwards.
I seem to remember reading in De Schutter's book last night, so I've put a note right on this. I thought there was very little agreement of how jus cogens is formed. There's a lot of criticism about the role which state practice plays in it. Basically, it's one of those things that nobody can really explain that well, and it's just incredibly problematic in human rights.
Yes, you're right.
So, just a parenthesis here. This is treaty. Very good point. This is custom. This is general principles. All these are methods, tools that we use in international law to create rules, okay? Obligations for states are stemming from each one of them, okay? And this is a pot where we are collecting rules. Rule, 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 rule. All these have been created through those means, okay? In everyday life, in international law, those rules were reciprocal, were bilateral, no hierarchy, what we know, okay? But some of those rules are special. They are jus cogens, and more are erga omnes. The question Sufyan is asking is, how do you put a stamp? But you say, well, you're not a rule like all others. You're special. You're number one. You're jus cogens. Who says? Who puts that stamp? And on the basis of what criterion? Is this a question?
The court.
Courts. Only the courts?
International treaties.
No, I don't know any treaty that says this is jus cogens. Basically, let's stick to international court. So we need an authoritative decision saying what is jus cogens. This creates a lot of problems. You know, it's not something isolated international in law. You know, it's we have this kind of stuff. Several different fields of law. You know, I come from practice. I was a practitioner. So I know that in several circumstances we need the authority to see what the law is, what it's not. Okay? And this is a very good illustration of that we need an authority to say what it is, what it's not. But this creates a problem as well, because the Inter-American Court of Human Rights said that the principle of non-discrimination, in an advisory opinion, which is not mandatory, but which has lots of legitimacy, it says that this principle is customary, is jus cogens. Does the court explain how it comes to this conclusion? Did it explain? Anyone? It didn't explain. What it said is, because of the value, the high value of this rule, because it's very important, because it's a rule that's fundamental to the international legal system, it is jus cogens. This is what the court says. How does, yeah.
So what makes something of a higher value or fundamental than the rest?
That's the problem, isn't it? The court is not, We are having this discussion, and Vasilis thinks that this is not use cognate. I agree with him, but I'm a lot Latin American as well. So the thing is, we have the same principle in the Charter of the United Nations, the beginning of the Charter, and we have the same principle in several other treaties and everything. So the court is not alone when it says that this principle is use cognate. But it's very polemic. It's not, we don't have agreement among all scholars that this is use cognate. And least of all, we don't have agreement among states that this is use cognate. So it comes back to your position that states are not agreeing with this. Not our states agree with this. I'm going to give you an example of a case that I was discussing last week in Manchester. It's a very interesting thing. We are discussing whether stateless people without any citizenship, how do they appear today in the world? And in the end, there's one specific situation that we have stateless people appearing, which is conflict in some countries, in which human and children only have their citizenship because of their husband, or parents, or father. So when the men disappear and they flee the country, they don't have any document, they don't have how to prove their citizenship, and many times they state their state of origin, reject their citizenship, saying that they never had it, because it was ancillary to the citizenship of the man. And I don't know how many states still have this kind of practice. I've heard something about 20, 30 states in the world. It's a great number, 200 states. So this is only one illustration that states will not agree that this is use cognate. No? And then it comes to another thing. I think I'm going to start finishing. 2 more points and then I finish. There's an inflation of of human rights, of jus cognans, especially in human rights terms. I studied, I did my PhD in Essex. Essex is very known for human rights and everything. I talked to some of my colleagues there, and everything is jus cognans. Lots of human rights became jus cognans in the view of some people. I don't think it's like that. But yeah. But the point is, how does this impact international law? If you have a branch of international law inflating the concept of jus cognans, do we have a fragmentation of international law? Is this international law, or is this something different? What do you think?
Just to make this point about fragmentation more practical. You remember in week 2 that we discussed the Gaftir case about the torture and whether this is jus cognans and whether would you ever torture, would you ever, okay?
Yeah.
How many torturers there were in the class? I don't remember. I try to forget that. So, in that case, the European Court of Human Rights said that torture is a jus cognans, is peremptory, is absolute, no matter what, you will never torture. And I told you that in that case, there is no space for proportionality, okay? Why? Because proportionality is a tool that allows assessing to what extent the limitation is possible, okay? Permissible. You are allowed to enter into your neighbor's house if you have a fire in your house and you want to save your life. Okay? If there is no fire, you're not allowed. But when it is jus cognans, it is absolute. Never. You will never torture someone, even if it is at stake the life of your child, your father, your mother, etc. Okay? Do you remember the Vallanatos case last week? This case has to do with, it is a same-sex couple. In Greece, there is a law on civil partnership, and the law on civil partnership says that this is only for a man and a woman, but not for two. I know you're married, sorry. Not for two men, okay? And the same-sex couple goes to the European Court of Human Rights and says, you cannot create, you cannot exclude us from a law. This is discrimination on the basis of sex. And the European Court of Human Rights says, well, yes, it might be. But let's see, are there any good reasons that would explain this, that would justify this? And then the court applies proportionality. So, European Court of Human Rights, non-discrimination, it applies proportionality, it is not jus cogens. The Inter-American Court of Human Rights, labor rights, you cannot discriminate. Why? Never. Why? Because it is jus cogens. Europe says non-discrimination is non-jus cogens. And Latin America says no, discrimination is jus cogens. Who is right, who is wrong? What do you think?
Clearly we're right.
Eh?
Clearly we're right.
You're not part of Europe. Very shortly you will not be part of the European Convention on Human Rights.
You think Europe is
For
right?
2 years, I'm right.
Yes, you're right.
You think the European Court is right on this?
No, I think you're wrong, actually. I don't think we're right, but specifically I think you're wrong with regarding saying discrimination is
Jus
jus cogens.
Why?
So
Well-
he likes discriminating.
I'm the white racist in the room, obviously. You say the principle of equality before the law and non-discrimination is developed in international case law and legal writings, but the principle of non-discrimination applies to those who are equal before the law. So those who are unequal before the law, i.e. an undocumented illegal immigrant, they can be discriminated against
The
because of
American
that.
Court says
Very careful with that.
equality also is
Yeah,
jus
it's-
cogens.
Very careful with that. It's, the
Well, this is what
court
I'm
is
saying
saying,
wrong. I mean, if this is what you're saying, I disagree with it.
no. What I'm saying is that you can have laws enacted by the state that violate international law. And this is what the Inter-American Court is saying. The laws that discriminate between workers because some workers are undocumented, these laws violate the Inter-American Convention on Human Rights. And on top of that, violates one provision in the Inter-American Convention, that's the provision on non-discrimination, which has jus cogens correct. Anyone else? Sorry, is that correct?
Sorry, I'm not following your argument.
Because, let's go back. Maybe I didn't follow your argument before. Can you repeat that?
Basically I'm saying the principle of non-discrimination applies to those who are equal before the law.
So
Which law? Which law?
So a precondition for discrimination is equality, which is not always the case.
Which law you are?
I think we're trying to make a differentiation between equal protection of the law and equality before the law.
Okay, what's the difference?
For example, like within domestic law, there is jurisdictions because some people are considered to have more of a privilege than the others. So to put them on the same footing, they're given reservations and stuff. That isn't equality, but they're equally protected by the law. Once you raise everyone to the same platform, then there's equality. But equal protection is just irrespective of where you come from, what you do. There's certain equal protection of law.
Okay.
I was gonna, related to your question, if who's right or wrong, I don't think there's a right or wrong. I think the courts are answering to different institutions and different societies. But I don't know if it could be said.
So in Europe we can't discriminate, but
No, not like discriminate. No, I don't think. I don't know. No, I don't think you guys can discriminate. I don't think that's a law anywhere. Not even if you are British, surely.
Just to open a parenthesis here, with regard to equality, we'll have a seminar on the Covenant on Socio-Economic Rights, and there I will give you an article that gives different grounds for equality, different explanations of equality. Equality is a mega philosophical issue. You have big philosophers who have been trying to establish what is equality, what is etc. It is an endless debate. But if your argument, technically speaking, is that non-discrimination presupposes that someone has been given a given right, and the law doesn't give the same rights to all groups, okay, in the sense that we have rights of children, which do not apply to, other social groups. and in that case you cannot apply non-discrimination, yes, technically speaking, you're right. But the point here was a different one. Let's focus on non-discrimination. You have the Inter-American Court of Human Rights, and you have a government that goes and says, well, I have lots of migrants, they go to another country, sometimes it is unregulated migration, this is a politically correct way to say unlawful migration, okay? And they don't get the same benefits, they don't have the same rights, they don't have the same protection, okay? And the Latin American court, because also of the cultural... Inter-American, sorry. Because of the also the circumstances of the case, it goes and makes a big statement. It doesn't simply say, you know something, yes, you should not discriminate. It says, you should not discriminate because this is jus cogens. It is fundamental, it is peremptory, it is number one, okay? Do you think it is fundamental? Do you think that there are some circumstances that would allow discriminating?
Yeah.
An example.
Well,
No, that's okay. Thank you.
if you're living outside the law, you can't expect to have the
What's
benefits of
the
the
law?
law.
Sorry, what's the law?
Any law.
No, it's not any law, because we have different things. We are approaching this from an international law perspective, international human rights perspective. So you can have state law saying something, and it makes sense in the state, but then this, what the state law is saying, is found to be in violation with international law. So what the state is saying, that it's equality before the law or everything, may be and has been several times, not only in this case, in several others, in several other cases, have been, well, listen, you are violating the non-discrimination because this kind of discrimination that you are making is not accepted. It's just that. But we don't need to enter this kind of discussion. We don't need to enter this kind of discussion. Because, why we don't need? Because we are talking about the implementation of the principle of non-discrimination. We don't need to go there. We don't need to see whether the court was right or wrong to say that, because the court didn't say the United States was violating. It was not. It was an advisory opinion and everything. And it said, you cannot, pursuant to this information, you cannot discriminate in this circumstance. I'm not saying that this is right or wrong. What I'm saying is, the court said that the principle of non-discrimination, respective of whether it applied that principle, in that case, rightly or wrongly, but it said that the principle per se is jus cogens. And this is the point. Yeah.
If non-discrimination is jus cogens, then why is there, when it comes to CEDAW or ICCPR and stuff, why are states allowed reservations?
They're not allowed reservations. What do you mean, reservations in the intercontinental?
Like, they ratify a treaty or a convention, like for CEDAW, and there are certain things based on certain grounds they say we're not going to follow points 1, 2, 3 because this.
Yeah, but you are going back to state practice, and then you are bringing something that's very complex.
I'm
which
not
is
bringing state practice. I'm saying.
No, when they make reservations, this is state practice. When they make reservations to treaties.
I think I understand what you mean.
Yeah.
The answer is here. How did a particular rule has been created? Through treaty, custom. Okay. We created the rule. Okay. A state, unless if it is custom, when a rule stems from a treaty, can simply enough say, I don't like that treaty, I don't sign it. Okay? Or it can say, I will sign it, but I will not be bound by Article 9, which is freedom of religion.
Yeah.
This is fine. Once a state has been bound by a rule, then the rule produces effect. Some rules are given an extra effect, are given a super, and this is the jus cogens.
So if they're able to make that reservation and say this doesn't apply to me, how is it a peremptory norm from which no derogation is allowed?
So the question is, do you think that in order to have jus cogens, you cannot have reservations?
Yeah, so the point of jus cogens is that there is no derogation. if the fact that there's that reservations
before
that's
that,
allowed
there must be a
means
rule.
that it's not applicable to everybody equally and that there is a derivation from it.
Okay,
So it takes away the entire essence of what a use cogence norm is supposed to be.
yes, but what about the norms that become rules that become use cogent? What happens to reservations if a rule become use cogent?
There can't be such rules which become use cogents when you can claim a derogation from it.
But then they
No,
can
no,
no longer
You can,
claim
you
that
can, you
derogation.
can. Law is not static. Law develops.
No, if I have a state religion and you're saying non-discrimination is a thing, but if I want to place reservations and say women are not going to be discriminated, but like because of religious practice they're going to have to wear burqas and we're not going to sign and ratify that part of it, how does it become a use
Okay,
cogence
this
norm when you're allowing
debate of
someone to
whether
derogate from it?
the egg make the chicken or the chicken make the egg. Why? Let's go
I don't know, I guess.
90 years, let's go 90 years ago. No use cognizance exists, nothing like that. That was a clever point, but let's focus on it. So, two states, they sign an agreement because they are sovereign and they bind themselves, okay? This is classical international law. Because of sovereignty and sovereignty being absolute, initially states could sign any kind of agreement they wanted. But then you have some scholars, Verdres, who says, well, there should be some treaties that are forbidden. And this is the same logic as you, like you saying, well, there should be some things that you cannot make a reservation against them, okay? You cannot exclude yourself from it. So
Yeah,
you
like
have,
for example, torture, you can't say, based on whatever else, religion or whatever, I'm going to claim an exemption from torturing these people for this thing. Like practice may be different, but the fact that you place an express reservation on something is completely different. Like stoning of women still happens. And that's not because of a reservation placed. That can be accounted as torture, but that's state practice.
okay, can a
It's not-
state simply say, I don't want to be bound by the prohibition of torture?
No.
No. Why?
Use cogence.
Yes,
And-
but use cogence to exist. So imagine this is torture and this is use cogence, okay? For it to exist, it needs to somehow emerge as a rule. How it emerge as a rule?
State, consent of state, state will.
Yeah, but then
No, not always, not necessarily. Custom. Use cogence traditionally are customary rules. They are rules that exist there irrespective of the will of states. They are there somehow. And you have a huge issue there because many people say, well, there is no state practice supporting torture, etc., etc. But this is where morality comes into play, and so you have a judge somewhere who says, this is use cogence. This applies irrespective of whether you agree, irrespective of whether you want to limit it or not. Sorry.
You raised the point of the consent of the state.
Right.
And the other thing that I try to call your attention about this opinion is that the background is, I think you said that the background is individual-centered. And it's individual-centered, but it's not only that. The background is that what we have, especially because one of the judges in this advisory opinion, Cansado Trindade, the background is a background of international constitutional law. That states sometimes will be bound.
I'm sorry, I don't understand what international constitution.
Okay, so let's not go there. Yeah, the background is that there are some rules in international law that do not depend on the state consent.
Did you read my paper?
Sorry?
Did you read my paper on your reading list?
No.
Yeah, but we don't need to go
International
there.
constitutional law.
We don't need to go there. Let's stay before that. There are some rules that do not depend on the state consent. And this is the background here. No. Because
And even before that, international law stems from sovereignty. Sovereignty means state consent as a precondition for me to be bound.
Okay.
But because also of human rights, and this is something we will see next week, and the idea of
That's limiting the
the
sovereignty.
humanization of international law,
Right.
which is linked with the constitutionalization of international law. Please do read my paper. It's the best paper you've ever read in your life. It is great. It is, yeah. Anyway, so Because also of human rights, you have this debate of human rights come to push sovereignty. They push the traditional understanding of international law stemming from consent. This is reflected first of all in customary law. Okay, customary law in a sense is coming as general practice accepted as law to create rules that bind states even against their sovereign will. Okay, and we need it because without custom we wouldn't have the prohibition of genocide, we wouldn't have the prohibition of torture, etc. This is the first step. Then the next step is also those rules that are so fundamental, we need to give them an extra label so that we know, we recognize that this is something special. Erga omnes, and then most importantly, jus cogens.
So what happens if there's a derogation in that case then?
If it is a derogation, you mean reservation, derogation?
Derogation, I'm saying if there's a jus cogens
You cannot have a derogation.
But what if it happens? Then what
then if you have a court, the court will sanction it, will say you cannot have a derogation, you cannot go against it. Okay? Even when you have a limitation, the court will say, no, you cannot have a limitation, no matter what. Why? Because this is jus cogens. But the issue, the key point Sufyan, I think, is raising with this case is, who has the authority in international law to tell us what is jus cogens? And this is an example of a court ex cathedra. So imagine Antonio Gonzalo Tridalo. Do you know the guy? He's taller than me, much more fat. I know this is difficult, but he wakes up in the morning. He has 3 scrub decks, 6 packs of bacon for breakfast. And says, "Well, non-discrimination is jus cogens. Who will stop me? I'm the president of the Inter-American Court of Human Rights. Jus cogens." What is the rationale behind it? What is the reasoning? What are the criteria? If you read Article 53 of the Vienna Convention, it says that this needs to be unanimously accepted. He gave you an example about stateless people. 30 states disagree with that. Still, we are debating whether it is jus cogens. Jus cogens is a magical tool, a fetish. We have created international law to limit state will. And there are many doubts as to what is jus cogens and what are the criteria for establishing jus cogens. And you have examples of disagreement between courts. We discussed torture, the European Court of Human Rights versus the Supreme Court of the United States. This is another example. Latin America says never non-discrimination. The European Court of Human Rights says, yes, we can't discriminate, let's apply proportionality to see whether this is permissible or not. This means fragmentation of international law. If you ask me, is non-discrimination jus cogens? I don't know. The Inter-American Court says yes, the European Court of Human Rights says no. And if you ask my ounce, you might have another opinion. The second issue, inflation. We will see this also in the ICJ judgment for next week. Because jus cogens is like a fetish, like a magical, we're attributing to it magical dimensions, it's a mythical concept in international law. Everything that we want to say it is important, we say it is jus cogens. The prohibition of the use of force, this is jus cogens. Torture, yes, this is, but I told you, and this is something we discussed 2 weeks ago. Putting the label and saying this is jus cogens has consequences. It means you will never be allowed to torture no matter what, no matter how painful it is for you. If you say non-discrimination is jus cogens, this means that every migrant who is in this country, irrespective of whether they came here lawfully or unlawfully, they should have exactly the same rights as someone who is lawfully here. Or as native speakers, locals, citizens. You cannot discriminate, they will have exactly the same NHS standards, they will have exactly the same access to education, they will have exactly the same, this costs money. How can you have someone like a Brazilian judge sitting there and says, well, I don't care about your budget, this is jus cogens. Why? It is fundamental for me. Why? I'm a good Christian.
But in the language of Article 53, can you then tell us how discrimination can be permitted in certain circumstances that allows for derogation?
What do you mean in the language of 53? How you're making the connection with the VCLT?
So the VCLT says that.
And we need to finish in exactly 2 minutes.
Yeah. So the VCLT says that it describes a norm from which no derogation is permitted and which can be modified only by subsequent norm.
Okay, I see what you mean. We will discuss again this in more detail. We discussed last week limitations on the basis of proportionality. There are other ways as well to escape applying human rights obligations. One of them is exception, okay? So immunities that you will need to discuss next week with the ICJ is an example of an exception from the right to access to justice. You have the rule, but we have an exception, a conflicting rule which is more special, more narrow, and it applies. Then you have the idea of derogation. We will discuss in the seminar what derogation from human rights obligations means and when this is permissible, and you will see what is meant by that. But the point here is that Article 53 is many pages ago. It's outdated. Why? Because Article 53 was reflecting what jus cogens was in the 50s, 60 years ago. This is how the concept was starting. But jus cogens now applies outside treaty law, and it applies even when there is no unanimity as to whether a rule is jus cogens. How? We don't have an established method. This is a big lacuna, this is a big gap in international law. If you ask a lawyer, what is it that makes jus cogens? We all know the effects, okay? Nullity, peremptory, etc. But what are the criteria on the basis of which jus cogens is jus cogens? No answer. We are waiting for scholars who may disagree, and then some scholars, like Antonio Cansado Trindade or Nino Cassese in the ICTY, they become judges, and their scholar opinion, they have a stamp and they say, well, this is now the court's. Or you have the ILC, but behind the ILC it is still people. We'll have to leave. We'll continue next week. Read please the ICJ